My dad named me as the executor under his will, which was written 30 to 40 years ago. Is it still good? The answer to this and a few insights of the estate planning path in just a moment. First, I'd like you to think about a friend who may be struggling with a what-if scenario that creeped into their lives, but they were better prepared because you shared our videos. We would appreciate it, as will your friend. I'm 𝘢𝘷𝘦𝘺𝑗𝑚𝑒𝑑𝑰, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please, drop us your questions, and hopefully together we're going to help some folks along the way. Now, if it is the most recent expression of your father's wishes, and there's no evidence of his intent to revoke those wishes, then it may still be used. Certain actions do evidence a person's intent to revoke their estate plan. Perhaps they have several versions of prior copies, and then there's a newer original. That would be a good evidence to see that those prior ones are no longer valid. But this does become more questionable, and other factors have to be considered if, say, you find a copy of a will or other estate plan and there's no original. The original documents, by the way, are much more important when it does come to a last will and testament that will go through the court and probate process, as opposed to some of the other estate planning forms, which often these days is acceptable in copy form. However, something of importance that I should mention, and the reason I have the estate planning path up here, is that an estate plan should be reviewed every few years, right? It is highly unlikely that your life circumstances remain the same between the first time you establish a plan and when you ultimately pass. Your planning needs to adjust as your life changes. For instance, if you're looking at the estate planning path, 30, 40 years ago, maybe you were a parent with minor children under Section B here. However, over time, you may acquire more assets. You head towards retirement or in retirement or need some kind of long-term care assistance. All of these different stages along the estate planning path have an impact on the type of plan that you will need and require. As such, that's why it's really important that you confer with legal counsel who can give you insight at each of these relevant stages and stay on top of things for you. We hope that this information is helpful to you, that you've learned something new here today, and that you choose to share. As always, please take care.